Never panic when someone builds on your land. Panic when they stop leaving evidence. The first thing I noticed was not the houses. It was the sound. 96 different lives were already beginning before anyone realized they had been built on the wrong piece of ground. Lawn mowers hummed across freshly seeded yards. Nail guns echoed from the final homes still receiving trim work. Delivery trucks rolled slowly along brand new asphalt while children chased bicycles around cul-de-sacs that had not existed the last time I stood on that hill. The smell of fresh lumber mixed with newly poured concrete and blacktop still warming beneath the late afternoon sun. Bright white mailboxes lined streets that only months earlier had been nothing more than open pasture and oak trees my family had protected for generations. At the entrance stood a polished stone monument proudly displaying the neighborhood name beneath the logo of the Homeowners Association. Decorative flags fluttered in the wind beside perfectly landscaped flower beds, and beyond them stretched 96 completed homes arranged with almost mathematical precision. It looked like a thriving American community. It also happened to be sitting on my land. I parked my aging pickup truck at the highest point overlooking the development and stepped into the warm breeze carrying the faint scent of fresh paint and cut grass. Nobody paid attention to me. Construction supervisors drove past in utility vehicles. Real estate agents escorted smiling couples through model homes. Families measured windows for curtains while moving trucks unloaded furniture onto driveways that crossed property I legally owned. I reached behind the driver's seat and carefully removed a long weathered survey tube that had traveled with me for years. The faded cap still carried my father's handwriting in black marker. Inside rested an original boundary survey that had been completed decades earlier by a licensed county surveyor. I slowly unrolled the map across the hood of my truck, allowing the corners to flatten beneath the weight of two small stones I picked up nearby. Every contour line, every legal description, every iron survey marker appeared exactly where I remembered. Then I lifted my eyes toward the neighborhood again. The entrance road, the clubhouse foundation, the retention pond, the sidewalks, and nearly every completed home sat comfortably inside the legal boundary printed on that old sheet of paper. About 50 yards downhill, hidden beside a mature oak tree that developers had somehow decided not to remove, an original steel survey monument still stood exactly where it had been driven into the ground more than 40 years earlier. I walked to it slowly, brushed away loose dirt with my boot, and smiled when the stamped survey number became visible beneath a thin layer of clay. It had never moved. That single marker quietly confirmed everything I needed to know. Someone had trusted the wrong map. As the evening sun settled lower across rows of freshly finished rooftops, I rolled the survey back into its protective tube, returned it to my truck, and watched another moving van disappear around a corner. I felt no anger, no urgency, and no temptation to confront anyone standing below. Concrete dries. Houses sell. Paper endures. By the time the last roof was finished, every permit signed, every closing completed, and every family settled into their new homes, the evidence would be impossible for anyone to deny. They believed they were building a neighborhood. I knew they were building the strongest case I would ever carry into a courtroom. My name is Nathan Walker, and that weathered survey tube resting behind the seat of my truck had been part of my life for as long as I could remember. My father used to joke that paper was lighter than concrete but far more difficult to move once the law recognized it. As a child, I never fully understood what he meant. I only remembered following him across open fields while he pointed toward old oak trees, shallow creeks, stone fence lines, and weathered steel survey markers that looked too ordinary to matter. He would stop every few hundred yards, unfold the county survey, and explain that every boundary carried a story written long before any road or neighborhood appeared. Those afternoons eventually became my education. Long before I invested in commercial timber or managed conservation properties, I learned to respect documents that most people never noticed. The land surrounding that hill had belonged to my family for more than 70 years. My grandfather purchased it shortly after returning home from military service, believing that land was one of the few investments capable of protecting future generations without ever speaking a single word. Over the decades, portions of neighboring farms changed ownership many times, but our acreage remained untouched. We never mortgaged it. We never divided it. We never sold the ridge overlooking the valley because my father insisted that one day someone would underestimate the value of boundaries they failed to understand. Every tax bill had been paid on time. Every deed had been properly recorded with the county. Every updated assessment reflected the same legal description carried forward year after year without interruption. Inside a fire-resistant safe at my office rested the original deed bearing the official county seal, preserved inside an archival sleeve beside decades of tax receipts, title insurance documents, correspondence with surveyors, and certified copies of every recorded transfer connected to the property. The survey tube I carried contained only a working copy, but it matched the original survey completed by a licensed county surveyor in 1981 after permanent steel monuments had been installed across the entire boundary. Before leaving the hill that afternoon, I photographed each remaining survey marker, recorded their coordinates, and quietly documented the progress of construction from several public viewpoints. I never crossed temporary barriers or disturbed a single worker because there was no need. Evidence gathered carefully always carries more weight than accusations made emotionally. As I drove away, heavy dump trucks continued delivering landscaping materials while crews planted young maple trees along sidewalks that curved across my property with remarkable confidence. Decorative streetlights stood ready for evening, and freshly painted curbs reflected the golden light of sunset. Everything looked permanent, successful, and expensive. That appearance would eventually matter because every completed improvement increased the legal consequences of building in the wrong place. Back at my office, I unlocked the safe with the small brass key my father had handed me years earlier, removed the original deed, and placed it beside the certified survey. The county seal remained crisp despite its age, and every page carried signatures that had survived generations without losing their authority. I closed the folder carefully, returned everything to the safe, and locked the door again. Outside, 96 new homes continued moving toward completion. Inside that quiet office, every document needed to determine their future had already been waiting for decades. Rebecca Monroe had never considered herself reckless. She considered herself efficient. That difference explained almost everything that happened next. As president of the Homeowners Association for Silver Creek Estates, she had earned a reputation for making decisions quickly, speaking confidently, and expecting everyone around her to keep moving at the same pace. Residents admired the beautifully maintained entrance, seasonal landscaping, neighborhood events, and spotless common areas. Builders appreciated that paperwork rarely sat on her desk for long. Somewhere between confidence and convenience, however, verification quietly disappeared from the process. The development had originally been planned years before Rebecca joined the board, and each new phase relied heavily on engineering drawings, planning binders, and digital maps passed from one consulting firm to the next. Every meeting ended with another colored presentation showing future streets, parks, drainage ponds, and additional homes stretching neatly across the valley. No one questioned whether every property boundary had been independently confirmed because everyone assumed someone else had already done that work. During one planning session, an outside survey consultant reportedly raised concerns about a boundary discrepancy near the northern ridge where my family's land overlooked the project. Instead of commissioning a complete verification, the concern was dismissed as an outdated mapping inconsistency that would eventually be corrected during final documentation. Construction continued without interruption. The developer trusted the engineering package. The engineering package relied on previous planning documents. The Homeowners Association trusted the developer. Each layer of confidence rested upon another assumption rather than the original county records. Rebecca often reminded board members that delays cost money and uncertainty discouraged buyers. New phases moved forward exactly on schedule. Roads were paved. Utility lines were installed. Sidewalks stretched across gentle hillsides. Decorative stone walls framed neighborhood entrances while young maple trees were planted beside freshly poured curbs. Sales offices celebrated every completed closing with photographs posted across community newsletters. Families proudly collected house keys, believing they were beginning new chapters in a carefully planned neighborhood. Standing quietly on the ridge above the valley, I watched those celebrations from a distance without interrupting a single one. I never blamed the families because they purchased homes believing every legal requirement had already been satisfied. My concern rested entirely with the decisions made long before they arrived. Each weekend I returned with a camera, a notebook, and the same weathered survey tube resting behind my truck seat. I photographed progress from public roads, documented completion dates, recorded visible survey monuments that remained untouched, and saved aerial imagery showing each stage of construction. Month after month, another foundation became another house, another driveway, another occupied address. Every improvement quietly expanded the permanent record of what had been built and exactly where it stood. Rebecca occasionally appeared at ribbon cuttings, smiling beside newly installed neighborhood signs while congratulating contractors for finishing ahead of schedule. She believed efficiency had delivered another successful community. I believed patience was preserving something even more valuable. Every permit approved, every deed transferred to a homeowner. Every certificate of occupancy issued, and every official announcement celebrating the completed neighborhood strengthened a timeline that could later be verified beyond dispute. They were constructing far more than homes. Without realizing it, they were carefully documenting every step of the strongest property case I would ever bring before a court. By the beginning of the following spring, the neighborhood no longer resembled an active construction site. It looked complete. Fresh sod covered every front yard, sprinklers traced slow arcs across the grass each morning, and newly planted maple trees cast small shadows over sidewalks that had become part of people's daily routines. School buses stopped at the entrance before sunrise, delivery vans disappeared through quiet streets throughout the afternoon, and families walked their dogs beneath decorative streetlights each evening. From the ridge above the valley, I watched an entire community settle into a rhythm built upon land they believed had always belonged to someone else. Every few weeks I returned with the same camera, the same notebook, and the same weathered survey tube resting behind the seat of my truck. I parked only on public roads, respected every construction boundary, and photographed the development from legal observation points. Each visit added another page to an organized record that included dates, weather conditions, visible progress, aerial imagery, county mapping updates, and photographs of every original survey monument that remained untouched along the property line. The steel marker beneath the old oak tree never moved. Neither did the legal boundary it represented. I also retained an independent licensed surveyor to verify every measurement without informing the homeowners association or the developer. He completed his work using modern equipment while referencing the original county survey completed decades earlier. Weeks later he delivered a sealed report confirming exactly what my family's records had already shown. The permanent boundary had never changed. The development had simply expanded across it. I placed his report beside the certified deed, tax history, title records, and archived surveys already waiting inside my office safe. My attorney reviewed every document carefully before offering the same advice each time we met. Do not interrupt construction, he told me. Allow the record to become complete. Every permit issued, every closing completed, and every improvement finished establishes measurable facts that no one can later dispute. His reasoning was not emotional. It was entirely legal. A completed project creates a complete evidentiary record. I trusted that advice because rushing into court before the facts fully matured would only invite unnecessary arguments over incomplete damages or unfinished work. Meanwhile, Silver Creek Estate celebrated milestone after milestone. Promotional photographs appeared online showing smiling families receiving keys to newly completed homes. Rebecca Monroe stood proudly beside developers during ribbon cuttings, thanking contractors, engineers, and board members for delivering another successful phase ahead of schedule. Local newspapers praised the neighborhood for bringing new housing opportunities to the area. Reading those articles never made me angry. Instead, I quietly clipped each one, recorded the publication date, and added it to my growing file. Public announcements often become valuable evidence because they establish timelines no one later questions. By early summer the final crews removed temporary fencing, planted decorative flowers around the entrance monument, and replaced construction signs with permanent neighborhood markers. The sound of heavy equipment slowly disappeared, replaced by lawn mowers, children playing basketball in driveways, and evening conversations drifting across front porches. Looking down from the hill one last time before driving home, I realized there was nothing left for the builders to finish. Every road had been paved. Every roof had been installed. Every closing had been celebrated. The strongest part of my case would no longer be what I claimed. It would be what they had already completed with remarkable confidence, believing the ground beneath every foundation belonged to them. The morning after the final certificate of occupancy was issued, my attorney placed a thick folder on the conference table and quietly smiled. He had been waiting for that moment almost as patiently as I had. Every page inside represented another completed piece of the timeline we had spent months documenting. The independent survey, the certified deed, county tax records, archived aerial photographs, engineering reports, planning approvals, newspaper articles announcing construction milestones, and photographs taken from public roads were now arranged in perfect chronological order. Nothing depended on speculation anymore. Every fact had been confirmed by documents created by different people at different times for different purposes. Together they told one remarkably consistent story. My attorney slid a single civil complaint across the table and asked me to read the final page before signing it. I did. Every description matched the evidence exactly. There was no dramatic language, no accusations beyond what the document supported, and no attempt to exaggerate the situation. It simply identified the legal owner of the property, described the encroachment, listed the completed improvements, and requested judicial relief under state property law. I signed my name, closed the folder, and watched him file the case electronically with the county court before lunch. The lawsuit became part of the public record only after every home had been completed, every street accepted, and every recorded improvement could be independently verified. Several days later, official notices reached the developer, the Homeowners Association, and the attorneys representing the project. According to my attorney, the initial reaction inside their legal offices was disbelief. They assumed the filing involved a minor boundary disagreement affecting one corner lot or perhaps a misplaced fence. That assumption disappeared the moment they compared the legal description attached to my complaint with the county parcel records. The disputed area extended beneath nearly the entire completed neighborhood. Rebecca Monroe reportedly requested an emergency meeting with the developer and the association board that same afternoon. Survey maps covered the conference table while engineers, consultants, and attorneys compared digital planning files against original county records. The more documents they reviewed, the quieter the room became. Every modern drawing eventually traced back to the same outdated mapping error that had never been verified against the original recorded deed. Confidence slowly gave way to concern. Concern quietly became urgency. While those meetings continued, I returned to the ridge overlooking the neighborhood one more time before the first court hearing. Children rode bicycles along sidewalks sparkling after an overnight rain. Mail carriers placed letters into rows of white mailboxes. Garden hoses watered flower beds beside front porches where families drank coffee without realizing lawyers several miles away were studying the land beneath their homes. I never blamed those families. They had purchased homes in good faith and trusted professionals to confirm what should have been confirmed long before construction began. My dispute had never been with them. It rested with the decisions that ignored original records while assuming newer paperwork must automatically be correct. Standing beside the old steel survey monument beneath the familiar oak tree, I brushed away a few fallen leaves and looked across 96 finished homes glowing beneath the morning sun. The same marker my father had shown me decades earlier remained exactly where the county surveyor had placed it. Concrete, brick, and asphalt had transformed the landscape around it, but that small piece of steel still defined the legal boundary without speaking a single word. Within a few weeks, that silent marker, together with the deed waiting inside my attorney's leather briefcase, would enter a courtroom where paper, not assumptions, would finally determine who truly owned the ground beneath every foundation. The courthouse stood quietly beneath a clear autumn sky, its limestone walls reflecting the early morning sunlight as attorneys, surveyors, and county officials moved through the front entrance carrying thick document cases. I arrived with nothing more than a leather briefcase, the original deed secured inside an archival folder, and the same weathered survey tube that had traveled behind the seat of my truck for years. My attorney greeted me with a calm smile before leading us toward the courtroom assigned to the case. There was no celebration, no dramatic anticipation, only the steady confidence that comes from knowing every important fact had already been preserved long before anyone entered the building. Across the courtroom, Rebecca Monroe sat beside attorneys representing the Homeowners Association and the developer. Their table overflowed with engineering drawings, digital renderings, planning binders, permit records, and construction schedules. It was immediately obvious they had invested enormous effort preparing to defend the project. The judge entered promptly, welcomed both parties, and explained that the purpose of the hearing was to determine the legal ownership of the disputed property before addressing any additional issues. That single statement quietly reminded everyone why we were there. Before discussing neighborhoods, houses, roads, or financial consequences, the court first needed to answer one simple question. Who owned the land? The developer's attorney spoke first, describing years of planning, county approvals, infrastructure investment, utility installation, environmental compliance, and the successful completion of 96 family homes. He emphasized that hundreds of professionals had participated in the project and argued that everyone involved had relied upon existing planning documents believed to be accurate. The presentation was polished, detailed, and supported by colorful exhibits projected onto large courtroom screens. When he finished, the judge thanked him and turned toward my attorney. Instead of delivering a lengthy argument, my attorney quietly walked to the evidence table carrying only one leather folder. He opened it carefully, removed the original recorded deed bearing the official county seal, and handed it to the court clerk. Next came certified copies of county tax records establishing uninterrupted ownership across multiple decades. Then he produced the original 1981 boundary survey completed by a licensed county surveyor together with certified archival copies maintained by the county recorder's office. Finally, he placed the independent modern survey completed only months earlier beside the historical documents. Without exaggeration or emotion, he explained that every independent source identified the exact same legal boundary. The judge spent several minutes reviewing the certified records while comparing legal descriptions line by line. Silence gradually settled across the courtroom as the pages turned. Rebecca occasionally whispered to her attorneys while engineers studied enlarged survey maps spread across their table. My attorney then requested permission to introduce one final exhibit. From the weathered survey tube I had carried since the beginning, he removed the original field map my father had carefully preserved decades earlier. Although it carried no dramatic appearance, every measurement aligned perfectly with the certified county survey already before the court. The judge looked from the historical documents to the modern survey and then toward counsel for the Homeowners Association. No one interrupted the quiet that followed because everyone understood what had just happened. The discussion had moved beyond assumptions, planning errors, or construction schedules. It now rested entirely upon legally recorded ownership, and for the first time since I had stood on that hill overlooking 96 completed homes, the same deed my family had protected for generations finally lay open beneath the courtroom lights where every signature, every seal, and every recorded boundary could speak for itself. The judge leaned back slightly before looking toward both legal teams with the kind of expression that appears only after every important document has finally aligned. Instead of announcing any immediate conclusion, the court requested testimony from the independent licensed surveyor who had completed the modern boundary verification using the original county records. He walked to the witness stand carrying rolled maps, certified field notes, and high-resolution photographs taken during his inspection of the property. After taking the oath, he explained each step of his work with remarkable precision. He described locating every surviving steel survey monument installed during the official 1981 survey, comparing each coordinate with the county recorder's archived measurements, and verifying every boundary using modern satellite positioning equipment together with traditional field methods. Large display screens showed photographs of the same weathered steel marker resting beneath the old oak tree where I had brushed away the dirt months earlier. The surveyor enlarged the image until the original identification stamp became clearly visible. He then overlaid the historical survey with his current measurements. Every line matched. Every monument aligned. Every legal description pointed toward the exact same conclusion. The developer's attorney questioned whether decades of natural changes could have affected the original monuments. The surveyor calmly explained that licensed survey monuments are designed specifically to establish permanent legal boundaries and remain valid unless officially replaced through recognized legal procedures. No evidence showed that had ever happened. The Homeowners Association presented digital planning maps prepared during the development process, but under careful questioning, their own engineering consultant acknowledged those drawings had ultimately relied upon an earlier planning layer rather than an independent verification of the recorded deed. That single admission quietly changed the direction of the hearing. The judge asked whether anyone involved in approving the construction had physically confirmed the original county monuments before roads, foundations, or utility corridors were installed. A long pause followed before the answer finally came. No. The courtroom remained silent as the implications settled over everyone present. The mistake had not been created by one dramatic decision. It had grown through a series of reasonable assumptions that no one stopped to verify against the original records. Rebecca Monroe lowered her eyes toward the documents spread across her table while the developer's representatives exchanged quiet conversations with their attorneys. No raised voices filled the courtroom because there was nothing left to argue about. Certified deeds, uninterrupted tax records, original surveys, modern surveys, preserved monuments, and county archives all pointed toward exactly the same property line. My attorney stood only long enough to summarize one final point. Every improvement visible within the disputed area had been constructed after the legal boundary already existed, not before it. Ownership had never changed. The landscape had. The judge thanked both sides for their professionalism and announced that the evidentiary record clearly established the location of the legal boundary. Questions involving remedies, compensation, and future property arrangements would be addressed separately, but the ownership issue itself had become unmistakably clear through the evidence presented. I looked toward the leather folder resting on counsel table where the original deed remained open beneath the courtroom lights. The same document my grandfather had protected, my father had preserved, and I had carried into court now rested beside the survey tube that had traveled with me since the beginning. Neither one needed dramatic speeches. Together they had accomplished exactly what my father promised all those years ago. Paper had quietly outlasted concrete. Several weeks later the court reconvened to address what came after ownership had been established, and the atmosphere inside the courtroom felt entirely different from the first hearing. No one questioned where the legal boundary existed anymore. That chapter had already been settled by certified records, original surveys, permanent monuments, and the deed my family had protected for generations. The remaining discussion focused on solutions that respected both the law and the families who had unknowingly purchased homes built in the wrong location. My attorney made something clear from the beginning. We were not asking the court to punish innocent homeowners who had relied on professionals throughout the purchasing process. They had acted in good faith. The responsibility rested with the organizations that approved, designed, marketed, and managed the development without verifying the original property records. The judge acknowledged that distinction and encouraged both legal teams to pursue practical resolution supported by the established facts. Over several days, engineers, financial analysts, title experts, and real estate professionals presented detailed proposals. They discussed boundary adjustments permitted under state law, negotiated property acquisitions, compensation mechanisms, title corrections, infrastructure easements, and long-term agreements that could protect residents while honoring lawful ownership. Every recommendation required careful review because 96 completed homes, public utilities, neighborhood roads, and common areas could not simply be treated as lines on a drawing. They represented families, investments, and years of planning. Throughout those proceedings I remained surprisingly calm. My goal had never been to create uncertainty for people who had trusted the system. My goal had always been to ensure the system finally respected the documents that should have guided the project from the beginning. Rebecca Monroe attended every session beside the association's attorneys. The confidence she displayed during neighborhood celebrations months earlier had been replaced by quiet reflection. At one point she addressed the court, acknowledging that the association had relied upon planning materials it believed were accurate without independently confirming the original recorded boundaries. It was not a dramatic confession. It was simply an honest recognition that assumptions had replaced verification. The developer likewise accepted responsibility for relying upon outdated mapping layers instead of requiring a complete boundary confirmation before expanding construction. Those acknowledgements did not erase what had happened, but they allowed negotiations to move forward with professionalism rather than denial. After extensive discussion supervised by the court, the parties reached a comprehensive framework that included compensation based upon independent valuations, lawful acquisition of the affected property interests where appropriate, correction of recorded documents, and protections ensuring every homeowner would receive clear legal title through properly recorded agreements. The judge reviewed each provision carefully before approving the settlement structure and commended both sides for resolving an extraordinarily complex dispute through evidence, patience, and respect for the law. Walking out of the courthouse that afternoon, I noticed reporters waiting outside, hoping for dramatic reactions. I offered none. There was nothing to celebrate about a mistake that had affected so many people. As I placed the leather briefcase containing the original deed into the passenger seat of my truck, I looked toward the familiar survey tube resting behind the seat. It had traveled with me from the first day I stood on that hill overlooking fresh foundations until the final legal documents restored certainty where assumptions had once ruled. The neighborhood would continue growing, families would continue building their lives, and the land would finally be governed by records that had quietly spoken the truth from the very beginning. Several months passed before I found myself standing on the same ridge where this story had truly begun. Autumn had given way to early spring, and the valley below looked peaceful in a way I had never imagined during those long months of surveys, legal filings, and courtroom hearings. Children laughed as they walked home from school carrying backpacks nearly as large as they were. Neighbors waved to one another while collecting their mail. Fresh flowers brightened front porches, and young maple trees planted during construction had already begun stretching higher toward the morning sky. The neighborhood no longer represented a legal dispute. It had become exactly what those families believed they had purchased from the beginning, a place to build ordinary lives. The difference was that every property interest, every recorded boundary, and every legal agreement now rested upon verified facts instead of assumptions. I parked my truck beside the familiar overlook and reached behind the seat one final time. The weathered survey tube remained exactly where it had always been. The faded writing placed there by my father had become harder to read over the years, but I could still recognize every letter. I carried it across the grass to the old oak tree and knelt beside the steel survey monument that had quietly outlasted countless meetings, engineering drawings, construction schedules, and legal arguments. A thin layer of leaves covered the marker again, just as it had the first afternoon I brushed the dirt away and confirmed what I already suspected. I cleared the leaves with my hand, smiled at the stamped identification number, and realized that nothing about the boundary had changed throughout the entire story. Only people's understanding of it had changed. Later that afternoon I returned to my office, unlocked the same fire-resistant safe with the small brass key my father entrusted to me years earlier, and carefully placed the original deed back inside its archival sleeve beside the certified surveys, tax records, and every court document created during the case. I paused for a moment before closing the safe because I finally understood the lesson my grandfather had passed to my father, and my father had quietly passed to me. Ownership is not protected by emotion. It is protected by preparation. It survives because someone preserves the records, respects the process, and remains patient when others mistake confidence for certainty. Rebecca Monroe eventually stepped away from her leadership role, and the association adopted new policies requiring independent boundary verification before approving any future expansion. Developers throughout the county quietly changed their review procedures after studying the outcome of the case. Engineers, surveyors, and attorneys began treating original recorded documents with renewed respect because one overlooked deed had permanently changed how an entire region approached large developments. I never considered that a personal victory. It was simply proof that the legal system works best when facts are allowed to speak without interruption. As I locked the safe and switched off the office lights, I glanced once more at the survey tube resting beside it. Concrete had reshaped the landscape. Roads had connected neighborhoods. Families had built new memories. Yet the smallest and oldest pieces of paper inside that safe had quietly carried more authority than every truckload of asphalt and every newly poured foundation. That is why I never rushed to stop the construction. I trusted that truth does not become stronger by shouting louder. It becomes stronger when it is documented, preserved, and finally placed before the right court at the right moment. In the end, the land did not belong to whoever built on it first. It belonged to whoever could prove it under the law, and sometimes the quietest document in the room carries the loudest voice.